Okay, good afternoon. Okay, good afternoon, everyone. Thank you for joining us for our May coffee hour with our own Scott Makokani. Scott is a graduate of William S. Richardson School of Law, Duke University, and Ka'u High School. He has been practicing estate planning and trust law in Hawaii since 1983. He is past chair of both the probate and estate planning section and the Estate and Gift Tax Committee of the Hawaii State Bar Association, and he is currently serving on the board of our own Senior Counsel Division. Okay, without further ado, Scott, this is your hour. Thank you.
Thank you so much, Gil, and thank you so much for inviting me to share today. I really appreciate this is sort of a reprise of past presentations, but I'll try and add some things and make it interesting for everybody. So when we start talking about estate planning and asset protection planning in particular, one of the things we really want to focus on is why we do it has really more to do with people. It has to do with us. It has to do with the people who would be affected if something happened to us. And so what is really critical when it comes to asset protection planning and estate planning in general is to realize that we do it for people. We're not trying to help anybody get away with anything. We're not trying to do anything like that. We're trying to help people, whether it's us, whether it's our beneficiaries, be in a position to be able to defend against claims in the best possible way. So what can be done? Well, one of the things we can do is we can realize that there's lots and lots of rules out there. And many of those rules apply to estate planning, apply to asset protection planning. But the really cool rule when it comes to estate planning is that we get to write our own rules. So what each of our estate plans ends up being is kind of a rule book that covers things like, well, what if there comes a time when I can't make decisions for myself, when I can't enunciate decisions for myself? Who's going to step in and make decisions for me? Do I want to build any special rules around how I pass assets on? For example, a lot of times parents want to benefit their children in their estate plans, but not necessarily their children's future ex-spouses or creditors, or sometimes it's appropriate to actually protect our beneficiaries against their own inability to hold on to assets, their own inability to say no to the friends and family who come around whenever there's a windfall or anything like that. So the what can be done is to realize that there's lots and lots of rules out there, including the rule that says we get to write our own rules when it comes to our estate plans. And then the how of estate planning and asset protection planning is process. We have to evaluate where we are, figure out what goals we want to reach, and then put the rules together that are going to get us and our loved ones from where we are to our chosen goals. Now, one of the important things to realize, especially when it comes to estate planning, is that there are things that are more important than avoiding probate and minimizing taxes. And really, the big one to me is control. I think that is the foundation of any well-planned estate. That is, I want to be in control of my stuff. I want to say who's going to take control later on if there comes a time when I can't be in control. And I want to say how my beneficiaries are going to be able to control what they receive. And if that sounds an awful lot like someone who is very controlling, yeah, maybe I am, but that's kind of the point of estate planning, is to make sure that the things that we think are appropriate and are important are actually going to be carried out through our estate plans. Now, the next level up from control is providing for me. And I've got my spouse there in parentheses, not because my spouse is unimportant. My spouse is very important. My spouse is one of the primary reasons for me to have an estate plan in the first place. But I word it like this in order to emphasize the point that you got to take care of yourself in your estate plan in order to take care of other people. It's kind of like when you take a plane trip and they do that safety briefing at the beginning and they tell you about the masks that could appear at any moment. And I've never been on a flight where the masks appeared other than in the safety briefing, and I hope I never am. But I know what to do. I grab the mask and I put it on the person next to me, right? Well, no, that's not what they tell you to do. They tell you to put it on yourself. Is that because we should all be selfish? No, it's because if you don't take care of yourself, if you're unconscious on that flight, you're not going to be able to help anybody else. So estate planning is kind of like that in the aspect that you got to take care of yourself to be in a position to take care of other people. Now, the next step up in this pyramid is providing for other family members. And then the tip of the pyramid is minimizing those taxes and expenses. So that's an important thing to do. And I didn't mean to minimize that at all when I emphasized control at the very beginning. Minimizing taxes and expenses is critical. But what we need to do, I think, is sort of address the issues in the order that I've presented them here in order to have an estate plan and an asset protection plan that really is going to work at the end of the day. Well, let me propose this definition of estate planning that sort of builds on the concepts that I just mentioned. First of all, I want to control my stuff while I'm alive and well. And I've never had anybody object to that. Everybody, wants to be in control of their stuff, of course. And then I want to plan for me and my loved ones if I become incapacitated. Now, the chances of me becoming incapacitated, the chances of anybody listening to my voice right now of becoming incapacitated between now and the day we die is about 70%. That's not real good odds. In other words, about 70% of us are going to need to have some kind of assistance, some kind of long-term care helping us out for some period of time before we die. So disability planning is something that we really need to build into our estate plans and make sure that is covered in our estate plans. And then ultimately, I want to give what I have to whom I want, when I want, the way I want. And when I die, and sorry folks, but this is 100% probability, when I die, I want to make sure my stuff goes to the people I love without unnecessary cost or delay or loss of privacy. So how do we do that? Well, there are a lot of ways of dealing with our stuff when we die. One way is essentially to do nothing. And that is to just let the law of intestate succession govern what happens to our stuff when we go. And, in some circumstances, that can be the perfect estate plan. That can work just absolutely well. But the chances of it working perfectly well in any given circumstance, I think, are pretty low. So intestate succession may not be the preferred route of passing our stuff on. And we'll talk about that in a little bit more detail. Another way to deal with our stuff is through joint tenancy or tenancy by the entirety. Joint tenancy, of course, can exist between any number of people, and family relationship is absolutely irrelevant to who can be joint tenants. You can have 10 joint tenants, you can have 2 joint tenants, but the way joint tenancy works is everybody has an equal share, and when one person dies, the title to their share pretty much automatically passes to the surviving joint tenant or joint tenants. And then the last one standing gets it. Now, tenancy by the entirety is an extra special kind of tenancy that it can exist between spouses. It can exist between civil union partners, reciprocal beneficiaries. But the rules around tenancy by the entirety is that there can be only 2 parties to the tenancy. And the really helpful thing about tenancy by the entirety is that creditors of one of the parties cannot touch the assets that are held in tenancy by the entirety. Someone who's a creditor of both members of that entirety can attack it and can attach it and perfect a judgment against it and execute on the judgment against it. But a creditor of only one of the parties cannot. So tenancy by the entirety should jump out at us as a real opportunity for doing some really cool estate planning and asset protection planning in particular. And we'll explore a little bit about into the flexibility of tenancy by the entirety and how it can work in a lot of different circumstances. Yet another way to pass our stuff on is through beneficiary designations. This would be life insurance, retirement plans, things like that, where you can say who gets the benefit from the plan or who gets the benefit from the policy or the annuity or whatever the asset is that you're able to designate the beneficiary on. So beneficiary designations are something that we need to be very careful with because there's no automatic protections built in around the beneficiary designations. So for example, if you name your 3 kids as the beneficiaries on your life insurance policy, you die, the proceeds go to the 3 kids, but what can happen is that if one of the kids gets divorced, boom, there goes at least half of their share. Another kid gets in a car accident or has some other liability situation, there goes that inheritance. And if one of the kids just isn't able to hold on to assets, well, that can blow the inheritance right there as well. So beneficiary designations are important. We need to deal with them in the estate planning and the asset protection planning process, but we got to be very careful with beneficiary designations because they don't come with any kind of automatic protections built in. Yet another way to deal with our stuff when we go is through will-based planning. That is to pass your stuff on by the terms of your last will and testament. Perfectly good, perfectly valid way to deal with your stuff. One of the things about will-based planning, though, is that whatever is going to go to your loved ones is going to have to go through the probate process if it's a will-based plan. And probate, definitely not the end of the world in all circumstances, but in almost every circumstance, it is worth avoiding just in terms of timing and in terms of ease of the process. So will-based planning, again, certainly very valid, and you can provide asset protection planning within a will-based plan, but you can do it just as well, if not better, through a revocable living trust-based plan. And so for most people, a trust-based estate plan tends to work out the best. Now let's talk a little bit about intestate succession. If you don't remember this from law school, they probably didn't teach it in law school, but a very important test, it's not a bad thing for lawyers to be aware of, is the 2-finger test. And the way the 2-finger test works is you take 2 fingers, preferably your index finger and your middle finger of one hand, and you press them to the wrist of the inside of the wrist of your other hand. And hopefully you feel this bumping sensation. Now, what that bumping sensation tells you is that at that point, you do not have any heirs. So intestate succession involves having your assets passed to your heirs upon your death. And if you think, well, that's not such a bad thing, well, if you follow the 2-finger test, what you know is that right now you don't have any heirs. I mean, you have people who we assume are going to be your heirs if they outlive you, but we don't know who's going to outlive you. And just by luck, the right people may die in the right order, but almost never does it work out like that in real life. So relying upon intestate succession may not be your best move. Mom's nightmare. This is a true story. Husband and wife got divorced because husband found somebody new. And when mom died, subsequent to the divorce, mom didn't have a will, but mom and dad had one child. They had a daughter. And mom passed everything by intestate succession on to daughter when mom died, because mom didn't have an estate plan in place, but the law said that daughter, as mom's sole heir, received all of mom's assets. Well, daughter unfortunately died shortly after that. And daughter's sole heir, because daughter wasn't married, daughter didn't have any kids, daughter had one surviving parent, and that was dad. So dad then inherited everything that had been mom's. Well, you guessed it, shortly after that, dad dies, and dad's sole heir is wife number 2. So all of mom's assets ended up going to the woman that mom considered the home wrecker, which gives rise to the title Mom's Nightmare. The absolute worst case scenario for mom, she never wanted her stuff to go to wife number 2, but because she didn't have any kind of estate plan in place, intestate succession took it exactly where she didn't want it to go. Now, don't have to tell you all about probate and how the various reasons that probate is an awfully nice thing to avoid. I mean, it can take a long time, it can be expensive, it can be aggravating for a lot of reasons. The whole probate process is really an invitation to a fight, if you think about it, because probate begins with sending notice out to everybody who might be happy to know what's in the will and everybody who might be unhappy to know what's in the will and who got nominated as personal representative and like that. So what probate does is it provides a forum for a fight. So for those reasons, probate is really nice to avoid. Yet another reason, and I think it's probably the most critical reason to avoid probate, and that is that probate is a public process. Anybody who wants to look at the court file can actually find out all kinds of information, even though a lot of things will be redacted and just by our court rules. Someone who's interested in finding out sort of who your family is, generally what you own, maybe where things are going, and be able to do who knows what with that information, makes probate as a public proceeding sort of distasteful for all of those reasons. So probate may not be the best choice, and intestate succession is almost never going to be the best choice for passing your stuff on. Well, let's dig in a little bit to joint tenancy. And let's just imagine a hypothetical family consisting of mom and pop. And let's say mom and pop have 3 kids, and let's just pick 3 names at random. Let's pick, I don't know, Mo, how about Larry, how about Curly? Perfectly good names. Well, let's say that mom and dad find out how easy and cheap joint tenancy is, and gosh, they don't have to see a lawyer, they don't have to get any legal advice, they don't have to really pay for very much, if anything, to put all of their stuff into joint tenancy. They can put their house into joint tenancy, mom, pop, and the 3 boys. They can put their bank accounts. They can essentially put whatever assets they own into joint tenancy. Well, let's say that mom and pop do this and everything goes well for 10 years. 15 years go by, everything is just fine. But then that one fateful day, Mo comes running in the house. Mom, Dad, got some bad news. Remember that car accident I was in about 3 years ago? Well, at the time of the accident, I didn't have the money to pay my insurance premium, so I didn't have any insurance. And it turns out that accident was my fault. I mean, these folks have taken me to court. They've proven to a jury's satisfaction that I'm responsible. And so now they're trying to collect on whatever I own. And, you know, I seem to remember, gosh, was it 15 years ago? You folks put me on title to the house. You put me on title to your bank accounts. Do you think that's going to be a problem? Well, just then, Larry comes running in. Mom, Dad, bad news. My wife has left me. She wants a divorce. And, you know, for some reason, she seems to think she's entitled to half of everything I own. And she happens to know that I'm entitled to your house and I'm entitled to your bank accounts. Oh, my. Is this going to be a problem? Well, what do you think? Is this going to be a problem for the family? Well, of course it is, because now there's at least 2 people out there, very motivated, very interested, very able to do things like force a sale of a house if mom and dad don't have enough money to pay off the creditor or the ex-spouse. So what mom and dad have done by creating joint tenancy and thinking they're taking the easy way out, is they've created some real problems for themselves and for their kids. So when it comes to the joint tenancy, we've got the creditor issues, that's Mo and the car accident. We've got the predators issue, that's Larry and his ex-wife. And don't forget, we've also got Curly sitting out there, and Curly falls into this very special category of beneficiaries that we call the baboos beneficiaries. And if you're familiar with the term baboos, you know that it means, to put it very kindly, simple-minded, maybe more accurately, it means stupid. It means the people who just can't hold on to assets. People who you give them something and in a very short time it's going to be gone, either because they've got bad habits or bad friends or just an inability to tell people no. What joint tenancy does is it not only exposes assets to the claims of creditors and predators, but it also sacrifices the opportunity to put rules in place around the inheritance of the baboos beneficiaries in your estate planning world. Well, let's talk a little bit about tenancy by the entirety. Now, tenancy by the entirety, I mentioned, is a very special branch of joint tenancy where if one tenant by the entirety passes away, title pretty much automatically passes to the surviving tenant by the entirety. It has the additional benefit of the fact that under Hawaii law, claims against either of the tenants by the entirety cannot be enforced against tenants by the entirety property. It would require someone having a claim against both husband and wife, both civil union partners, both reciprocal beneficiaries, whatever the relationship is that involves the tenancy by the entirety. So if somebody has a claim against both, the tenancy by the entirety doesn't really help you. But in, let's say, a husband-wife situation, husband goes out and gets in a car accident, the house is protected, assuming the house is owned by mom and dad as tenants by the entirety. So tenancy by the entirety is something that we can hopefully use and build on in various ways in the estate planning and asset protection planning process in order to protect our stuff. Now, the Hawaii law regarding tenancy by the entirety was defined primarily in the Hawaii Supreme Court case of Sawada versus Endo. And in that case, Mr. Endo had had a car accident with several other people in the other car, at least one of whom was named Sawada. And the Sawada car folks sued Mr. Endo, got a judgment against him, and came after him to try and enforce the judgment. Now, what the Sawada parties found out was that shortly after the accident, Mr. Endo and Mrs. Endo conveyed their home to their children. And the Sawada parties were incensed. They said, wait a minute, that's a fraudulent conveyance. You can't do that. You can't get away from creditors' claims by transferring the property away. And Hawaii Supreme Court said, well, maybe you can't do that, but in this case, the house was held in tenancy by the entirety. The Sawadas wouldn't have been able to touch it anyway. So the fact that mom and dad actually conveyed it to the kids was sort of no harm, no foul. There was no reason to reverse that transfer because the creditors couldn't have touched it anyway. Now, part of the backstory of Sawada versus Endo is that not too long after the transfer to the kids, mom passed away. Now, if the creditors had come along, if the Sawada parties had come along after mom had passed away and now dad owned 100% of the house, they would have been able to enforce their claims against it. So in that case, the Endo family sort of was a little bit lucky to have made that initial transfer so that the house was beyond the reach of the creditors when they actually got their judgment and tried to enforce it. Now, the Hawaii statute that deals with tenancy by the entirety is section 509-2A. And the statute doesn't limit itself to real property. There was a time when the statute was more or less interpreted as applying only to interests in real estate. But it's now become clear, both in Hawaii Supreme Court cases, and the Dean case, and the Au case, and in the statute itself, that interests in any kind of property can be held in tenancy by the entirety. So does that include membership interests in an LLC? Yeah, you bet. Does it include beneficial interests in a land trust? Yes, absolutely. Does it include bank accounts? Well, yes, it does, except the Hawaii financial institutions are smart enough that they don't let you put your bank accounts in tenancy by the entirety. And part of that is because tenancy by the entirety requires both of the tenants by the entirety to consent to any transfer of assets, so that in theory anyway, both husband and wife, or both of the parties to the tenancy by the entirety, would have to sign any checks, would have to sign any documents relating to transfers. And of course, financial institutions generally don't like the requirement that there be two signatures. They don't want to be responsible for policing that. So Hawaii institutions generally will not let you put a bank account in tenancy by the entirety. But mainland institutions don't always have that same sensitivity. So if you're opening an account with a mainland institution, you may be able to actually put it in tenancy by the entirety and have that protection that Section 509-2A of the Hawaii Revised Statutes affords. Now, up until about 2012, if you took your tenancy by the entirety house and put it in this pretty vanilla estate planning, put 50% into dad's trust and 50% into mom's trust, for example, or just, whatever the family situation happens to be, 50% in each spouse's revocable living trust, then chances are pretty good that you lost any tenancy by the entirety protection that you may have had. The good news is that our legislature, by statute, has now made it so that you can take your tenancy by the entirety property, put it into your trust, or you can put it into a joint trust, or you can put it into separate trusts with each of the tenants by the entirety having their own separate revocable trust, for example, and you can maintain that tenancy by the entirety protection. The only catches are that the trusts have to include the names of the settlors. So in dad's trust, it has to be dad's revocable living trust, and mom's revocable living trust, or the dad and mom joint revocable living trust. So the names of the parties have to be there in the trust. And there has to be some notation in a deed, for example, if real estate is being placed into the trusts, that says essentially that the parties are intending that the tenancy by the entirety protection afforded by the law is going to continue even after the transfers into trusts. And for whatever reason, and I'm sure there's a good reason, I just haven't figured it out yet. But what the statute says in terms of taking your tenancy by the entirety real estate, for example, and putting it into the trusts, is it says that the title has to be in tenancy in common between the two trusts, but as long as the deed notes that the parties intend that the tenancy by the entirety protection continues, then the tenancy by the entirety protection continues. So you just have to be careful to make sure that that notation is made in the deed by which real estate is transferred into trust. So let's talk a little bit about trusts and why they work so well. One primary reason that trusts are so effective at what they do is they actually divide ownership of assets between the legal, the title holding component, and the beneficial or the enjoyment component. Now, I like to say that there are 5 elements of a trust, and you may not find these in a textbook, and you may not have all people who work in this area agree that these 5 elements necessarily are the 5 elements that's necessary for a trust, but these are my 5 elements. First of all, you need a trust maker, and that's not really a legal term. Trust maker is you if you're making a trust. The person making a trust is the trust maker. So trust maker makes an agreement with a trustee to manage some stuff for the benefit of one or more beneficiaries. Now, under Hawaii law, and really the law of all 50 states, same person can be trust maker and trustee and primary beneficiary all at the same time. So most of the time when we set up revocable living trusts, that's exactly the way they work, that the client is the trust maker, trustee, and the initial beneficiary. Now, in order for the trust to exist in the first place, it's kind of like going back to contract law. There has to be consideration. Something has to change hands. Well, in the case of a trust, there have to be assets. So something has to go from trust maker to trustee, even if trust maker and trustee are the same person. So for example, to put real estate into your own revocable trust, you have to sign a deed from you as an individual to you as trustee of your trust. And then that piece of real estate is in your trust. Same thing with your bank accounts or any other assets that have title documentation involved, is you have to change the title documentation to make it clear that the asset is now held in the trust. And then the fifth element I have down there is the rule book. The rule book is basically the set of instructions that are going to deal with what happens to your stuff, that are going to deal with what happens to you, who's going to be able to make decisions later on. The rule book is essentially your estate plan. It's all the rules that you've put together to deal with all of those kinds of issues. And the part of your rule book that's going to govern your trust is called your trust agreement, or sometimes it's called a declaration of trust if it's basically a self-trusteed trust. But there is a trust instrument that's going to govern exactly how the trust is to be administered and where assets are to eventually be distributed. Now, when we get into talking about trusts, it's important to realize that there are lots and lots of different kinds of trusts. First of all, there's testamentary trusts, those trusts that are created by the terms of someone's last will and testament. Testamentary trusts are great for providing for management of your stuff after you're gone, but they don't do a thing for you and your family while you're alive because by definition they can't. Your testamentary trust cannot speak until the moment of your death. And then your will has to be admitted to probate. And then the terms of the trust set out in your will can then be carried out. And we're all familiar with some huge testamentary trusts in the state of Hawaii. Bishop Estate is governed by the will of Princess Bernice Pauahi Bishop. It's a great example of a testamentary trust. If you remember the Campbell Estate, it was governed by the will of James Campbell. Another great example of a testamentary trust that eventually had to be terminated because of the rule against perpetuities. Totally different set of issues. But the point is, testamentary trusts are out there. They're effective for what they do, but there may be a better way in terms of trust planning, and that is perhaps using living trusts instead of testamentary trusts. So a living trust is essentially a trust that you create while you're alive, rather than creating it by the terms of your last will and testament. And again, there are lots and lots of different kinds of living trusts, but the primary ones are what I like to illustrate with the little red wagon as the revocable trust. And then you have the irrevocable trust that I like to illustrate by way of the closed box. Now, with the revocable trust, you can take assets, and this may be your bank account, it may be all of your investments, it may be the deed to your house, and you put them into your revocable trust. And then what happens is, if something bad happens to you, your stuff doesn't end up in a mess all over the ground, which would be the case if you were just carrying it through life, right? You become incapacitated, you die. What happens to your stuff? Well, it ends up in that mess. If the reason for the mess on the ground was you became incapacitated, then the person who comes behind and cleans up the mess and deals with your assets and makes sure that what's left can be used for your benefit, that person is called your conservator. If the reason for the mess on the ground was you died, then the cleaner-upper of the mess is called your personal representative. Same thing as executor. In Hawaii, we just call it personal representative because that's the term used in the Hawaii Revised Statutes. So rather than have the mess on the ground, what you can do is take your stuff, put it into the revocable trust, and then if something bad happens to you, your stuff is in the trust. The only thing that hits the ground is the handle, but connected to the handle, fortunately, is your rule book, and your rule book contains the trust agreement that says, for example, who gets to pick up the handle and pull the revocable trust from here on out. Those are the successor trustee instructions. Your rule book is going to say what goes into the trust. Those are the investment instructions. It's going to say what comes out and when and to whom. Those are the distribution instructions. And they're all set out in the rule book that you've devised and that you've hopefully kept up to date over the years to make sure that your stuff is going to go where you want it to go. Now, in contrast to the revocable trust, and this is a really, really important distinction because of what I'm going to share with you now. Again, this isn't one of those rules that we learned in law school, but it's a very good practical rule to know. And that is what a beneficiary can touch, a beneficiary's creditor can touch. So when you take your house or whatever it is, assuming it's not a tenancy by the entirety situation, if you take assets and put them into your house and creditors come after you, get a judgment against you, because you can still reach into that trust and pull assets out, your creditors can do the exact same thing. Well, what if instead of having that open-backed vehicle, you had one that had a lid on it? So this trust, this irrevocable trust, has a rule book just like the revocable, but the rule book for this one essentially says that assets can come out, but only in very defined ways. And it may say that you can't reach in here yourself, but for creditor protection purposes, maybe you've got what the law would consider to be a neutral third-party trustee who can exercise discretion on your behalf. And in the Hawaii revised statutes, we actually have the approved Transfers and Trust Act that enables us to create irrevocable trusts for our own benefit. It used to be the case that you couldn't do that. You couldn't have what the law calls a self-settled spendthrift trust. But now the law of Hawaii and the law of several states actually allow you to do that. One important caveat, though, is that if you are not a resident of the state which you're availing the asset protection trust law of, very poor sentence, sorry, but if you don't live in the state where you created the trust, the asset protection aspects of the trust may not work for you. There is an Alaska Supreme Court case that says essentially that. Alaska is, at least tried to be, an asset protection haven, a jurisdiction where people could go to protect their stuff. And the trust companies in Alaska sort of encouraged the legislation and they encouraged trust business to come into the state. But the Supreme Court of Alaska has basically said, yeah, this works great for Alaska residents, but if you live in Hawaii and you come in and try and create an Alaska asset protection trust, forget about it. You're not going to get that same protection as an Alaska resident would. So whether the Hawaii asset protection statute would be interpreted the same way, who knows, but just beware that if you're doing asset protection planning by way of an irrevocable trust that you create under specific state law, it's probably much better to be a resident of the state where you're creating the trust. And in Hawaii, we are fortunate to be a state where you can create a self-settled asset protection trust. I also want to mention that Hawaii just adopted something called the Uniform Trust Code. It's Chapter 554D of the Hawaii Revised Statutes. And it has superseded a lot of the statutes that used to deal with trusts, including portions of the Uniform Probate Code, the Uniform Prudent Investor Act, the Uniform Trustees Powers Act. And generally, the terms of the Uniform Trust Code are not absolutely mandatory. There are a few provisions that are mandatory when it comes to trusts, but most of them can be sort of tweaked by the terms of your trust agreement. So that's kind of a neat thing to know. But just be aware of the fact that there is the Uniform Trust Code out there, and it applies really to all trusts, no matter when they were created. Now, certain rights that had vested prior to the adoption or the enactment or the effective date of the Uniform Trust Code may still apply, but generally speaking, whatever the Uniform Trust Code says about your trust governs unless your trust has a contrary provision. Well, I don't have a whole bunch of time, and I want to be sure and leave time for questions at the end. So I'm going to kind of rush through these last several points, but please bear with me. When it comes to planning for incapacity, one of the things we have to bear in mind that we may be the one becoming incapacitated, and it can be an issue determining whether I'm incapacitated or not. And anybody listening to my voice may say, well, clearly Scott's maybe doesn't have both oars in the water, or maybe people would assume I do. But in any event, in my rule book, in my trust agreement, I have provisions that say how I get to be determined to be capacitated or incapacitated. And generally, what is not a bad idea to consider is to have family members who know you and love you and would only, make this call if it were clearly in your best interest and your family's best interest, but essentially to set up a disability panel who can fire you as the trustee of your very own trust if circumstances warrant. I've seen this play out in real life in a circumstance where a senior family member developed, basically became very severely incapacitated as a result of a medical condition. And at the very end of his life, he took a large estate and made it a small estate with some very bad decisions. There was nobody in the family who could stand up to him and say, hey, granddad, you shouldn't be in control anymore. We need to have control, move on to somebody else because you're just not in a position to be able to make good decisions anymore. So having that disability panel, not a bad idea. And it can take it from being a sort of a public determination, if it has to go through the court, and makes it a private, makes it a family determination. So just something to consider. Remarriage protection is something that is important to a lot of people. It's important to me. It's important to my wife. Some of our clients, though, when we talk with them, they say, hey, I'm going to be gone. What do I care what happens to my stuff? If spouse wants to remarry and have everything go to the new spouse, well, that's their business. I'm going to be gone. I don't really see things that way. And for those of our clients who don't, what we do is we build into their trusts protections that will provide, let's say, for a surviving spouse, as long as they remain single. If they become married, though, certainly can't prevent that in the estate plan, but can say that spouse doesn't get to benefit from the trust anymore, or can say, well, spouse can benefit from the trust, but they just don't get to be the trustee anymore. Or you can build a variety of protections so that you can be pretty sure that what you leave behind isn't going to go to your next spouse's spouse and on to their kids to the exclusion of your kids. That is something to think about, and that is something to build rules around in your own estate plan. We've kind of talked about creditor protection and how we can build our trusts so that with that revocable trust that we talked about earlier, and we can say that upon the trust maker's death, the trust terminates and the assets go out to the beneficiaries, or we can actually say that upon the trust maker's death, a lid clamps down on this trust, and it actually morphs into a trust that looks like this. And we can give the beneficiary the ability to say who the trustee of their trust is. For creditor protection purposes, we're going to want at least one trustee to be a neutral third party. And by neutral third party, essentially what we do is we borrow from the tax law, section 672C of the Internal Revenue Code, and it's not a bad idea to say that there has to be at least one trustee who is not the beneficiary, is not the beneficiary's spouse, parent, descendant, sibling, or employee. But it can be pretty much anybody else in the world. It can be the beneficiary's best friend, their favorite uncle, their cousin, could be an in-law. So the idea is that when you leave assets behind, you can give your children their inheritance, each wrapped up in a pretty little box like this. And you can tell each of your children, look, you can be the trustee of this trust, the one who makes all the investment decisions. The one thing you can't do is make distributions to yourself. For that purpose, you need an independent distribution trustee. And that would be the person I just described, who is not the beneficiary, their spouse, parent, descendant, sibling, employee. And the reason it can't be any of those folks is because they're deemed under the law, or at least there are decisions in which this has been the case, that the person who is too closely related to the beneficiary is actually under the beneficiary's control. Now, we all know that we don't control our spouses, we don't control our kids, but the law assumes we do. So that if the trustee is too closely related and that trustee can reach into the trust, well, the beneficiary's creditors can too. So we need to create a little bit of distance there between the assets and the beneficiary if we want to provide that creditor protection later on. Same general concepts apply to divorce protection, where if you leave your stuff to your child in trust, and as long as the rules are followed and the children are very good about keeping assets segregated and using these assets only for the beneficiary's benefit and not commingling any of the assets or using marital assets to pay any of the bills related to assets that are in the trust, then we can be pretty sure that the assets that are left behind for the child are going to be there for the child and not the child's ex-spouse at some point in time. Special needs is something that we need to take into account, where we have a beneficiary, let's say, who is receiving governmental benefits. One of the things we don't want to do is leave that person so much in the way of assets that they lose those benefits. And so much in the way of assets, maybe $2,000 worth of stuff. So by giving someone $2,000 worth of assets, you can actually disqualify them from Medicaid and from a variety of other kinds of benefits that if you don't intend to do that, can end up being a real problem for the beneficiary. But what you can do, the good news is, that you can leave assets for the special needs individual in what I call a supplemental needs trust that can provide the extras that the government doesn't provide for, but is not going to disqualify that person from receiving benefits. Yet another thing we can do through our estate plans is promote certain values. We can encourage our kids to get an education by saying, hey, look, if I'm gone, my trust is going to pay for your education. And when you get your degree within 4 years of carrying a full load, you're going to get a special distribution that may even be enough for you to be able to buy a car. How's that? So we can build carrots into the estate plan. Or with some clients, unfortunately, we've had to build sticks. And that is, hey, in order to get a distribution from the trust, you got to pass a drug test. You can't have been incarcerated in the last year. So we can build our values both by way of carrots or by way of sticks, incentives or disincentives, to hopefully encourage the kinds of behavior that we think are important in our family members. And then finally, I wanted to talk a little bit about federal estate tax, just because the estate tax changes every year. So this year, the coupon, what I like to call the coupon, the IRS calls it the exemption equivalent, but I call it the coupon because it's kind of like they give you a coupon that covers so much worth of assets. Well, this year, the coupon is $12,060,000 for every individual. So between spouses, it's twice that amount. It's $24.12 million worth of stuff. And generally what this means is most of us do not have to worry about estate tax because we don't have enough assets to generate estate tax. Another adjustment that came in this year with the inflation adjustment was the increase in the annual exclusion for gifts. The annual exclusion is now $16,000 per donee per year. If you went to law school back when I did, you remember when the exclusion was $3,000, and then it became $10,000, and then $12,000 for several years. It's been $15,000, but the inflation adjustment as of this year, 2022, has brought it up to $16,000. The rate on the rate of the tax that's payable on the excess over and above the coupon amount on the federal side is 40%. The due date is within 9 months of date of death, and the IRS accepts cash in the way of payment. It doesn't accept real estate, doesn't accept chickens. So for some estates, liquidity can be a real issue, and I hope that's your problem. But if it's not, this conversation maybe is a little academic, but maybe you know somebody who can benefit from knowing some of these things. Portability is a really important aspect of the federal estate tax law. What portability means is that, let's say I have an estate of $1 million, but my wife has an estate of $20 million. If I die first, we've lost $11 million of my $12 million exclusion. But if my wife simply files a Form 706 estate tax return, she can appropriate the unused portion of my coupon so that she can take the $11 million, add it to her $12 million, and now she's got $23 million worth of coupon to shelter against distributions when she dies. So portability, really important to know that it's out there and to avail yourself of it in appropriate circumstances. Now, Hawaii, of course, has an estate tax as well as the feds. Our estate tax is a little bit different. For one thing, the coupon is $5.49 million instead of 12. And still, at $5 million per person, most people don't have to worry about even state estate tax. But there can be circumstances where there is Hawaii estate tax to be paid, even if there is no federal estate tax to be paid. And Hawaii includes the concept of portability in our law, so that is something important to bear in mind. The chances of having a 5 million plus estate are, of course, much greater than having a 12 million plus estate. And I hope all of us have estate tax problems before we die. So it is just about game over for the presentation. Sorry, I didn't leave a little bit more time for questions, but I'll stick around for as long as people want to ask questions, and I'll be glad to try and answer any that I can.
All right. Thank you, Mr. Scott Makuakani. Looks like we do have some questions in the chat box. Just a friendly reminder that this coffee hour is being recorded and will be uploaded in a future date sometime next week. But yeah, looks like we put your questions in the chat box, and looks like I got one question from Arlette. I think that's I believe. Sorry if I mispronounced your name, but what is the citation for the statute that provides that in order to continue to have TE protection names of settlers, and that the conveyance be to trust in common with language in the conveyance document, that the intention is for the TE protection is to continue?
Yeah, that would be that section 509 site that I gave you earlier. Let's see if I can reverse back there. Let's see. That would be section 509-2 of the Hawaii Revised Statutes.
Okay, and looks like we got a question from Catherine. What is the Alaska case citation?
Sorry, I don't have that off the top of my head, but that is one that you can probably look up fairly easily. The case is within the last 5 years, and I do apologize, but I can try and look that up, and if you want to contact me offline, I can get you the site.
All right, next question is from Malia. Can a property be in tenancy be by the entirety in other than 50-50 proportions? Could one trust hold 1% and the other hold 99?
It doesn't look like that under the law. It would be great if we could do that. But under the law, it's either going to be 50-50 in the two trusts, or it's going to be 100% in the joint trust. And that's just if you follow the literal terms of the statute. Is there room for fudge on that? Maybe, but I don't know that I would risk that. But it is possible to own a fractional interest in real estate and tenancy by the entirety. That's absolutely possible, and that fractional interest could be transferred into trusts. But I wouldn't venture far from either transferring the entire fractional interest into one joint trust or equal shares into two separate trusts. But again, that's just kind of trying to follow the statute.
All right, next question is from Sandra. If a couple have separate trust and 50% of real property in each trust, when one spouse passes, can the remaining spouse sell and use 100% of the property if needed for their care? Is it a good idea for spouses to each have a trust and put real estate 50% each?
Yeah, generally what we like to do is have separate trusts for husband and wife. And it used to be more tax driven. So you could get two shots of the coupon amount, because, I mean, it wasn't that long ago that the coupon was only $1 million. When I started practicing law, it was $325,000. For a long time, having the separate trust, separate husband and wife trusts, was driven by the tax law, the estate tax law. Now it's even more driven by creditor protection law, because what happens is with the trust of the first to die, we can build it so that it's going to be pretty much impervious to creditors of the surviving spouse, so that whatever's in surviving spouse's trust, remember it's that open trust, creditors can reach in there because surviving spouse can reach in there. But if we design the trust of the first to go correctly, we can build it so that creditors of the surviving spouse can't reach in here. And under the statute, it essentially says that creditors of the deceased spouse can't come after it either. So the fact that, one spouse dies, now it goes to the other one, but it's held in the trust of the first to go, it's probably still safe from any kind of creditors' claims. So using the two separate trusts, great idea for asset protection purposes, as long as you can build in the right rules into the trust agreement.
All right, next question is from Jacqueline. Is it wise or unwise to have one's revocable living trust be the beneficiary of a life insurance policy on the trust's life?
Yeah, it really depends on what your estate planning goals are. But almost never is it going to be a bad idea to have the trust be named as the beneficiary of life insurance, because you can protect those proceeds. If you're going to be buying a policy during your lifetime that you want to perhaps have available for liquidity later on, in terms of estate tax or just estate expenses or whatever it is, you can actually create a trust that owns the life insurance policy, and you never own it. So the proceeds that are eventually paid into this trust wouldn't be taxed as part of your estate. So if you had a taxable estate, that would be very attractive. But in any event, you can build it so that those insurance proceeds aren't going to be touchable by the creditors, the ex-spouse of the beneficiaries. So naming your trust as beneficiary of life insurance generally is a pretty good idea from an asset protection planning standpoint, because you can build those protective rules around the proceeds that wouldn't necessarily be available if the proceeds were paid directly to the beneficiary.
All right, next question is from Randall. If you have a revocable living trust, does that protect your assets so you would be able to qualify for Medicaid and have the state provide long-term care?
No, probably not. As a general rule, trusts and Medicaid don't go very well together. There has been a time in the evolution of Hawaii's Medicaid law when it wasn't a bad idea to create a trust to essentially give your stuff away. But if you maintain any kind of a beneficial interest in that trust, the trust is going to be countable for Medicaid purposes. Now, a revocable trust for sure is going to be countable because you can always revoke your trust and use it to pay medical expenses. So the assets of your revocable trust are going to be countable resources. So if you've got more than the $2,000 in the trust, yeah, you're not going to qualify for Medicaid. The only situations where it might be helpful to have your assets in trust when it comes to Medicaid planning is if you did it a long time ago. Or if you literally give up all beneficial interest in the trust, but still there are look-back rules when it comes to Medicaid qualification. So Medicaid planning is something really critical to work with someone who knows their way around the Medicaid rules very well. And there are a few practitioners in town who do. And I would encourage you to basically, if you're interested in Medicaid planning, find out who those folks are. Just by talking to your friends, talking to financial planners, other lawyers, and those names will come to the top. And those are the folks you ought to focus on dealing with in terms of Medicaid planning.
All right, this next question is from David. What criteria would you suggest for a trustee of your trust?
Well, my favorite professor from law school, Randy Roth, used to tell us, they don't call it a trust for nothing. Meaning that, of course, if you want to have a trust to be effective, what you're going to need is a trustworthy fiduciary to be in charge of the trust. If the person has special training, if they're a CPA or a lawyer or something like that, that's great, assuming they're willing to serve as your trustee. But your trustee really doesn't need to have that kind of special expertise. The main thing is that they would be honest, that they would be trustworthy, that they would actually read your rule book and follow it and do the things that you set out in your rule book. Those really are the main criteria. And if your trustee needs accounting or legal or investment or other kinds of help, trustee can always go out and hire that help and pay for it, out of the trust assets. So the main thing I would be looking for in a trustee would really be more the character issues. Of course, you want someone who's relatively bright, who's not going to be deceived or do dumb things with the assets. But really, trustworthiness above and is the qualification I would put above and beyond all others.
All right, this next comment is actually from Lisa. It's not more of a question, it's more of a comment, but she just wants to say thank you, Scott, for all the info. And looks like we have a question again from Sandra. Should husband and wife each be trustee for their separate trust?
Totally up to husband and wife. So it's not uncommon for husband and wife to be trustees of both trusts if they have separate trusts. But there's nothing wrong with having one spouse be the trustee of that spouse's trust, the other be the trustee of the other spouse's trust. One benefit of having the spouses be co-trustees is if they see their stuff as their stuff, as opposed to his and hers or whatever, then having both spouses as trustee means that, for example, either spouse could sign checks. Either spouse could deal with assets on behalf of the trust. And if one became incapacitated or if one passed, the other one would already be trustee and would already be in a position to be able to deal with trust assets. So I like where husband and wife feel comfortable, both of them being trustee of both trusts. I like that arrangement just because it's probably the most flexible as opposed to having one spouse be trustee of one, the other be trustee of the other.
All right, and this looks like this is our final question of the for today, I believe. Oh, wait, hold on. We actually still have more coming in. All right. Looks like there's another we have a question from Christine. Can an individual who has real estate property title held in irrevocable trust transfers with real property to the individual?
Just trying to parse the question, trying to understand it.
Okay. Okay, I'll repeat it. Can an individual who has real property title held in irrevocable trust transfer with real property to the individual?
Can you get the real property out of the trust? Is that the question? Or can you have an irrevocable trust with real estate in it? The answer is yeah, you certainly can have a trust with real estate in it. One thing practically to be aware of, though, is if you want to go out and get a home equity line or any kind of a situation where you're going to be using that property as security, most lenders won't let you do that. They don't like to deal with irrevocable trusts as a rule. But there's nothing wrong with having real estate in an irrevocable trust if financing, kinds of concerns aren't primary. So yeah, an irrevocable trust can hold real estate, and the real estate can be transferred wherever the rule book says the real estate can be transferred throughout the life of the trust.
All right, another question again from Sandra. Can beneficiaries force trustee to let them see the rule book?
Beneficiaries are entitled to know what's going on with the trust. And so generally, if a person has a beneficial interest in the trust, they should be able to see at least a portion of the rule book that deals with them. They don't necessarily have the right to see everything in the rule book, but certainly if they are trust beneficiaries, they probably have a right to the trust agreement. And that's one of those kinds of things that's covered in the new Uniform Trust Code. And that is just the need to give notice to trust beneficiaries of the fact that a trust exists, for example, that they're named in it, and providing them with a copy of the trust agreement. Trusts are great for privacy purposes, for keeping outsiders out, but beneficiaries are entitled to know what the trust says, and they're also entitled to be kept reasonably informed of the trust administration, so that the trustee would be required from time to time to provide a detailed accounting of the administration of the trust, and would also generally be required to keep beneficiaries reasonably informed as to what was going on with the trust. So in other words, if a beneficiary didn't want to wait for the final accounting or the annual accounting, but just contacted the trustee and started asking questions, those questions may actually be the beneficiary's business, and the trustee would probably be best advised to entertain those questions and provide whatever information is going to be helpful to the beneficiary, rather than try and keep any secrets or seem like they're trying to keep secrets from the beneficiaries.
All right, are there any additional questions in the chat? If not, I just want to thank Scott Makuakani again for coming in today, and I will pass on the mic to Gil for the closing remarks.
Thank you very much, Scott. Thank you very much, Desmond, and thank you for the support that you've given us, HSBA office. And thank you all for having attended this coffee hour. We hope you enjoyed it and very much appreciate your participation in SCD's coffee hours. Next month's coffee hour is the Economics of Aging in Hawaii, June 2nd at 12 o'clock. The speaker will be Dr. Andrew Mason, and our board member, Charlene Iboshi, was able to convince Dr. Mason to present. So with that, we all wish you a happy afternoon and stay healthy. Take care.